All righty. Good morning. Welcome, everyone. Let me live transcript. Hang on. Enable for this meeting. Okay. Someone asked to enable the transcript, so we'll do that. I'll get into some of the details for today. But welcome, everyone. My name is Jesus Azanza. I'm the Chapter Executive Director for the CAI Greater Houston Chapter. I'm also run the San Antonio chapter, and today we're excited to bring a great presentation. So before we get started, I want to recognize our committee members, and some of you are here. Jake Lightfoot, Sipra's on the committee, Jonathan Clark. There's a few of you on here. I don't see you all, but if you wouldn't mind unmuting and introducing yourselves.
Hey everybody, Jake Lightfoot. Thanks for attending the webinar today. Looking forward to a great 2022.
I'm Dawn Spencer. I'm also on the committee and looking forward to all the education series this year.
Lucy?
I'm Lucy Robertson. I'm a member of the Education Committee and also the CABL board member for our chapter. One of them, we have two now.
Athena?
Hey, good morning, everybody. I'm Athena Henriksen, been on the committee for quite a few years now. I'm so glad to see so many people have joined us today. This is an exciting time, especially that we get to bring it virtually to y'all. So thank you so much for joining us.
Teresa?
Hey guys, it's Teresa Cox. I'm almost also the sponsor today, so I'll be talking to you a little bit.
Did I miss anyone else?
It's Sipra. Hi. I'm also on the Education Committee and I'm the presenter today, so I look forward to presenting today. Good to see everyone.
Hi, this is Jennifer Northington from CI Services on the committee.
Roy Lively, Client Manager with Lead Association Management.
Okay. And Jonathan Clark is our Education Committee Chair, and he'll speak to you in just a moment, introduce himself. I wanted to recognize everyone just because there's a lot of effort that goes into putting these together. And so we want to make sure that we recognize the hours we put into putting this program together. So again, before I begin, if you wouldn't mind muting your mic just so that we can keep things on pace. I do want to introduce before we get started, our Texas Legislative Action Committee Chair, Chris Archambault, who's going to say a few things about our new legislative efforts in the state of Texas.
Thanks, Jesus. Hey, everybody. My name is Chris Archambault. I'm an attorney with Daughtry and Farine. As Jesus mentioned, though, why I'm here today is a little more important. I'm the chair of the Texas Legislative Action Committee, or TLAC. And for those of you who have been involved and are aware, previously CAI worked with an organization called TCAA. After the last few sessions, we've now transitioned to TLAC, which is more focused on the CAI chapters. So of the 4 chapters in Texas, we have delegates from each chapter that are going to be far more proactive in serving our industry, and that is going to start with you all. We are going to be upping our communications with you, letting you know what's going on, but first and foremost, we're going to be very proactive in the off session. Currently, we're in an off session year. The legislative session picks up again next year. But right now, we are putting a huge focus on fundraising. We're interviewing lobbyists to start representing us in Austin. But, a lot of this is a grassroots effort. So you are going to hear from the CAI chapters routinely. You're going to be hearing from business partners routinely to reach out to you, educate you on what's going on, what we need from you, because this organization is huge. This industry is huge and it should be represented in Austin, but that takes a lot of effort from not just the industry professionals, the management companies, but also the individual association board members. So we're going to be reaching out to you all a lot in the coming months to hopefully use you as a resource, use your connections that you have with representatives, with other business partners to get TLAC up off the ground, hopefully push our industry in the right direction. And, along the way, we'll be giving you monthly updates. Transparency is going to be a primary focus of ours. But it is going to require that everybody chip in, that everyone does their part, whether it's volunteering man hours, whether it's financial donation. We have a ton of committee positions open. If you want to get involved, please contact Jesus or myself. I understand at the end of today's presentation, we're going to be kicking out some materials to you to also educate you about TLAC. And for managers and board members, you know, when you have your board meetings, if you could give TLAC 10 to 15 minutes to come out and put a spot on their agenda, reach out to Jesus, and, you know, we'll be happy to send a TLAC delegate out there to educate your board, educate your members, and hopefully, you know, in the next session, we're a little bit more successful and we get our industry on the right track. Thank you, guys.
Thanks, Chris. Appreciate that. It's a great effort. A lot of work behind the scenes happening right now. So if you want to get involved, please get involved. All right, now we're going to recognize today's sponsor, Teresa Cox, Cox CPA Services. Teresa's been a long time member on several committees and sponsors everything that you can sponsor. You know, she's a bronze level premium partner of our chapter, which is an annual sustaining sponsor. And so we appreciate her support today and her input to get this program put together. So Teresa, I'm going to hand it over to you.
All right, thank you. Yes, I'm Teresa Cox with Cox CPAs, and most of you know me by now that I like to spend my time up here just asking a couple of questions and you provide the answers and we reward for participation. So how we're going to try to do this is use your chat box at the bottom of the screen. And when that little box, the panel comes up to the right, you can, I think it defaults to everyone, but you can either chat the answer in to everyone, or you can just pick me, Teresa Cox, and send me the answer. So here's what's going to happen. I'm going to ask a question. And when you think you know the answer, type it in the chat box, and the first person to get the answer correct will be rewarded. All right, so the first question is, what does ACC stand for?
All right, we've got,
so
was it Jennifer?
Jennifer, looks like Jennifer got the right answer first. It's Architectural Control Committee. And so Jennifer, if you can either send me in the chat your email address, or if you just shoot me an email, we will get you a $20 gift card to Amazon. All right, the next question is, what does CPA stand for?
Certified Accountant, Public Accountant.
Derek's here helping me. Allison got the answer correctly first. So Allison, you will get a $20 gift card to Amazon. If you just send us your email address, you'll get it over to you. And the last question is, what color represents Cox CPA Services? It went off the screen. I think somebody typed the answer before I asked the question. We're trying to get back down to the beginning. That was fast.
America.
Erica? Okay.
No, America.
It's like you knew what I was going to ask. Anyway, thanks for we'll get your $20 Amazon card to you, and thanks for participating. And all we ask is when you see purple, please think of us, or if you need an audit proposal, please think of us. All right, thank you.
Thanks, Teresa. Jonathan, I hand it over to you.
Thank you so much, Teresa. Thank you for your sponsorship, and good morning, everybody. Welcome. We have an amazing turnout today, which is so wonderful. This is an important and timely topic, the ACC, the Architectural Control Committee. And I know there's been a ton of attention with regard to the topic brought up largely with Senate Bill 1588, and now with the separation of board members from serving on the ACC. And I know that SIPR is going to go into great detail about those issues. But at any rate, it's wonderful. I think that Jesus said we have more than 200 people on the call right now. I am the chair of the Education Committee. It's been my honor to serve in that role for many years, and I have a great committee. Jesus introduced and the committee members introduced themselves, but I want to say thank you again to the committee members. We've put together a slate of educational programs for the whole year. Some of them are going to be virtual like this, and some of them are going to be in person. So be looking for the notices, and hey, I hope we can fill a room with 200 people just like this. That would be an awesome event. So with that, I'd like to introduce today's speaker, and we are very grateful to have Cipra Boyd, not only as a member of the Education Committee, but also as a past president of the chapter. Cipra is an attorney with the law firm of Roberts, Markell, Weinberg, Butler, Haley. She has practiced and dedicated her practice to community association representation for over 20 years now. She is also board certified in property owners association law, as well as residential real estate. And so with that, I'm going to turn it over to Cipra. Cipra, we look very forward to your presentation.
Thank you so much, Jonathan. I appreciate this opportunity. Good morning, everyone. It's so nice to see everyone's, well, some faces, but certainly a lot of names I recognize. Thank you so much for joining us. All right, I'm going to try and share my screen, and let's get that business out of the way. Can everybody see my screen? Get a thumbs up. Yes, okay, perfect. Thank you all so much. All right, so we're going to hop right in. If I can get my, oh, okay. All right, we're gonna hop right in. Although I'm really excited to get back into in-person events with CAI Houston. I know, like Jonathan and Jesus have said, it's really nice to be able to also appear during these webinars so that more people can attend and participate virtually at the very least. So today we're going to talk about the roles and responsibilities of the ACC, or the ABCs of the ACC. So let's dive right in. The information that's presented today is based on the law as it exists today. As you all know, this is all for educational purposes only. So if you do have a specific question that relates to your community or a particular situation that you're dealing with, I encourage you guys to contact your own legal counsel and ask them those questions. Today's presentation is intended to be kind of like a 30,000 foot perspective of the ACC process and just all of the new legislation that we're dealing with. So the agenda for today is going to talk about what are architectural control guidelines. Should you have an architectural control committee? I'm going to spend a little bit of time talking about the hearing on the ACC application denial, which is another recent legislative change that we need to talk about and the process for that. I'm going to also touch on the approval process and violations, as well as the post-approval process and violations. And then we're going to end up talking a little bit about how to respond to homeowners when they might have pending deed restriction violations or delinquent assessments. How do you deal with those when you get an application, and what can and can't you do? So what are architectural control guidelines? Generally speaking, architectural control guidelines are your deed restrictions. I know all of you have been bored or unable to sleep at home, and if you will pull up your architectural control, your deed restrictions, you'll see a lot of provisions about what a homeowner can and can't do, either to their property, exterior of their house, landscaping, the color of the home, where the home can be located, whether the house can be a one-story, a two-story home. All of those provisions in your deed restrictions are architectural control guidelines. And those lay the framework for what the community is eventually going to look like, or if you're buying a house in a community that's already been developed, you know, it laid the framework of what you're seeing and why you're probably purchasing that house. Unfortunately, or fortunately, I guess, depending on how your community was created, sometimes specific issues related to architectural control may not have been contemplated during the initial development process. And so there might be some holes in your restrictions, in your declaration about specific issues. And there might be some ambiguity about in the deed restrictions about what you can and can't do, or specific architectural control aesthetics. And so it might be that you'll find these other architectural control guidelines in a separate document. that either the developer didn't or didn't create, or potentially the association through the board or the ACC will later create. In terms of architectural control guidelines, typically the specific issues that the architectural control guidelines attempt to address maybe have to do with more aesthetic issues that you would see on the exterior of a home, or specific issues that you might deal with in your community. If the developer didn't institute those types of guidelines, then like I said, the association through the board or its architectural control committee should consider adopting guidelines. Now I say should because you have to be authorized to adopt guidelines. We do look for authority for the adoption of those guidelines, and typically you'll find that authority in the ACC or the Architectural Control Committee section. It'll talk about the makeup of the ACC and the authority of the ACC, and in that authority, oftentimes you'll see the authority to also adopt additional architectural control guidelines. Like I stated, the guidelines will provide owners with information on the approval of colors for exterior paint, fence requirements, landscaping requirements, the location of ancillary buildings or outbuildings, the size, the setback of where buildings can be located. Lots of other issues that dictate what your community eventually is going to look like. What's really important when you're looking for architectural control guidelines or you're drafting architectural control guidelines, especially if they're separate and apart from what you find in your declaration. Let's say your declaration is not very specific. If you are adopting guidelines, it's really important to not contradict your existing restrictions. So your declaration is kind of the Bible of your community. It's going to be the initial framework for the community and what the developer initially adopted in terms of what you can and can't do as an owner. If for whatever reason the developer laid out a specific fence size, fence height, for example, 6-foot fences, then later on, if the association or the ACC decides to adopt architectural control guidelines, the guideline should not contradict that. The guideline should not say fences may be 8 feet in height. They really need to make sure that they comport with the deed restrictions and not contradict them. There are certain times when you can use guidelines to clarify the restrictions. And again, this is a topic that's received a lot of case law attention. So I encourage you guys to work with your legal team on this issue. But one case in particular that comes to mind deals with the definition of temporary parking. A lot of times deed restrictions might state that recreational vehicles may be parked temporarily on the driveway in front of the home. Well, what does temporary or temporarily mean? There is a case that says if you're going to enforce some type of a time limit restriction, then it would be best for you to define the word temporary and place that in some type of a policy that is also recorded in the real property records, because everybody on this call knows that unless it's recorded, it's not enforceable. So guidelines are really helpful in terms of clarifying some restrictions and defining restrictions if there's no specific definition in the deed restrictions. But again, it's really important to work with your legal counsel to make sure you're not contradicting your restrictions, and also to confirm that the definitions are in fact something that could be upheld in a court of law if they were challenged. All right, so the next part that we're going to segue into is, should you have an architectural control committee? And I know this is an important topic that's on everyone's mind, especially because of the last legislative sessions. And most often the deed restrictions will, in a majority of the associations, or almost all of them that I've seen, they will require the approval of the ACC or the Architectural Control Committee before an owner can construct new improvements or make modifications to existing improvements. So look for that language, because if that's in there, then you should have an ACC committee. Why should you have an ACC committee, or what's the importance of having one? Well, one, if your deed restrictions require it, then you need to have one. But two, by establishing a committee, then the association can maintain efficiency for the members of the community. The committee is the place where all your new construction and modification applications will run through, and there's guidance in your restrictions about what the roles and responsibilities of the ACC will be and should be, and it creates efficiency in that process. It also, and some may snicker at this, will establish new positions for community members to become involved in the association process. And I hear some of y'all are rolling your eyes and saying, well, CIPRA, part of the problem is that we don't have enough people on the board. How can we find more people to sit on the ACC? Well, we're going to talk about that. I don't necessarily have the golden answer, but I understand that volunteerism is a problem in community associations, and we're all frustrated with this new legislation. But assuming that you do have a community, and there are out there that have lots of vocal people that want to participate in the association process, then really this ACC process and having a committee gives people the benefit of being able to participate in an association function that may not be, the board, but some other committee. It also establishes consistency with modifications and alterations in the community. Oftentimes what you'll see is communities have transitioned and developed over time, and there's not necessarily a consistent framework, at least architecturally or aesthetically. And that's because there's not any guidelines that were ever adopted initially. And sometimes when you're approached with some new issue or new application, or an application with some new item, you may not know how to handle it because it's never been part of the community. It's never been applied for before. So having guidelines will help with maintaining consistency on how you treat an application that maybe has something new or something similar that's been dealt with before. And then finally, it does separate board duties and architectural control duties, which for whatever reason, the legislature thought was really important. So we're having to deal with that situation.
Super, we have a question.
Oh, sure.
Is what can be done if you and your association has done everything in their power to get a committee together, but no one will volunteer? Can you just, pretty common, right?
Yes.
Can just one person do it that lives in the community, or can you outsource to an association management company?
Yes, good question. And that's something I'm gonna talk about. I think if you can only find one person, then the one person has to be the one that does it. If you can outsource it and have the authority to outsource it, then that might be really the only other option you have, assuming no one else is willing to do it. This issue is really, really fresh, effective September 1, 2021. So until we see kind of some of the fallout or the case law and the legal challenges to this issue, we really don't know what the answer is yet. But I'll talk about that specific question a little bit more in a few minutes. So back to whether or not you should have an ACC committee or an ACC and why that's important. It again maintains efficiency and it creates a smooth process. We encourage having some type of an architectural control process policy in place that helps homeowners kind of navigate that architectural control process. Sure, your deed restrictions talk about it, but where do I go to find the application? Where do I go to determine whether or not I can do XYZ? Can I put in above ground pool? Can I put in landscaping, or what types of plants can I apply for even? And if you have a policy or guidelines, then it's easier for homeowners to navigate that process. Also important to have an application. I know that some management companies have an application portal where everything's kind of uploaded to this portal. And that is absolutely very helpful. But sometimes all homeowners do are upload plans. They don't necessarily provide an explanation or description of what architectural control application modification they're wanting. And sometimes if you have an application that has general information about what the application will contain, or the plans will contain, that also kind of helps to make the process a little bit more efficient. The application should be readily available to homeowners, and certainly encourage placing any of the governing documents, the application, the policy for the application on the association's website to make that easily accessible.
They don't look there, but yeah.
That's true. I heard that comment. I know that that's part of the frustrating process in having to have and maintain an association website. The goal is to make it easier for you guys to say you can get it here, but most often I know they will say, well, but we'd rather just you give it to us because we're lazy. But let's talk now and more about the new legislation and how that's impacting all of you guys on this webinar. In the 2020 first legislative session, we had several new, but one particular new amendment to the Texas Property Code in Chapter 209, specifically Section 209.00505. And this is where a lot of our questions are coming from. Now, associations with more than 40 lots that are not under developer control have to have an architectural review authority. What's an architectural review authority? It's actually defined in the statute as the governing authority for the review and approval of improvements within a subdivision. So it's your architectural control committee, your architectural review committee. I've seen it called probably 20 different things: the design review committee, the modifications committee, the new construction committee. It's whatever the entity is that is to be established in your restrictions that is in charge of reviewing applications for construction and modification. This did become effective September 1st, again, 2021. So make sure if you can, you're establishing an architectural review authority. Now, the second part of the legislation, which has been lots of fun, is the limitations on who can serve on the Architectural Control Committee. The ACC member cannot be a current board member, a current board member's spouse, or a person residing in a current board member's household. So that's obviously presented lots of challenges to everyone on this call. Lots of legal challenges and questions that have come to us as well, because oftentimes the board of directors is, by virtue of actually specific restrictions in your declaration, also functions as the association's ACC. So now what? Well, as of September 1, that can't happen. And the follow-up question is, well, if that can't happen, what the heck are we supposed to do? Because it was like pulling teeth to even get these 3 people to serve on the board. I get that. A couple of options that we've talked about possibly doing is using your management company as your ACC. Now, this is kind of complicated because I think ultimately, well, one, maybe your management company may or may not provide this function, but 2, you have to have the authority to delegate that responsibility to an outside party, and your restrictions may be silent on that. So again, this is an issue that you need to work with your legal team on to see, well, can the management team handle this? And then what does that process look like? Surely the management company is probably going to have additional fees that they're going to need to charge because they're taking on another function for the association. And what are those fees, and how much time is this going to take, and what is this process going to look like? If the managing agent or the management company can't do it, or if you don't have one, right? This applies to associations with more than 40 lots. I mean, if you're a 45 lot community, you have to have a separate architectural review authority. You may be self-managed, and you may not have the option of using a management company. All of this ultimately, as we all know, what that does is increase potentially the assessments that you can charge, which is also limited many times. So a very complicated situation, but we're all in the same boat together and trying to navigate this. So all we can do really in our efforts to comply with the most recent legislation is do our best. The other option is to use a third party. There are some mostly commercial, but I know that there are residential architectural review companies out there. This again will come with some associated costs, but if you can delegate that function to an independent third party company, then that's also an option. Back to the person that had asked the question about, well, what if only one person's serving and you're required to have 3? I really think, you know, that's a really difficult issue, but if only one person is willing to serve, and that even sometimes happens on our boards, then you get what you get and you got to do your best. And if a homeowner is upset about that, or, you know, feels like this is something that they want to challenge, well, maybe encourage them to get on the ACC, because really the lack of people that are offering to be volunteers to help the conundrum that we're all in is the true problem. Everybody wants to complain, but nobody wants to participate and help fix the issue.
Cipra, one more question. I don't know if you can answer this, but can you speak to personal liability for ACC members?
I can, generally speaking, you know, a lot of restrictions talk about limitations on personal liability for ACC committees. And even if they don't, I think that ACC members as volunteers are probably typically, and I say that with an asterisk, covered under the association's directors and officers insurance policy. So 2 things. One, there should be very limited liability, if any, of an ACC member, because all you're doing is reviewing applications and approving or denying them. And typically in your restrictions there, you're shielded from liability by an express limitation. But if you're not, or if you do get sued in connection with the scope of services that you've provided as an ACC member, then make sure that your association has directors and officers insurance. But as a volunteer of the association, as long as you're acting in the course and scope of your duties as a volunteer, you should be covered either under your D&O policy, well, absolutely under your D&O policy, but also there are some federal and state statutes that protect you as a volunteer. But that's a whole nother webinar that we can spend another hour on. But in terms of liability, there is some, absolutely, anytime you do anything, there's liability, but there are some greater protections as well. The second part that I know we need to dive into, that is also part of the new legislation, is this ACC denial process. A lot of you on the webinar are familiar with the 209 hearing process, where if a homeowner is sent a notice of violation because of some compliance issue, then they're entitled to request a hearing in front of the board, and there is an entire process for that. In the last legislative session, that entire process, as it relates to 209 hearings for compliance issues, changed. And I don't want to spend too much time on it, because again, that's a different webinar, but that process has significantly changed, and it's turned into somewhat of like a mini trial, where the association has to send out a packet of information. The association has to go first at this hearing and state its case in chief. And there should be some evidence that's brought to this 209 hearing on compliance. This is different. When we're talking about an ACC denial hearing, it's actually a different process, and it follows the process that used to be in place for 209 hearings on compliance. So let's dig in a little bit more on this issue. When you get an architectural control committee application and the committee reviews it, if the application is denied, or there's some type of a conditional approval, we're going to approve it, but on condition that, then the denial letter has some really specific requirements that need to be included. And again, I would encourage you to work with your attorneys to make sure your denial letters comply with the law. So create some type of a template that you can modify for the specific issue, but has the same basic language that tracks the legislation or the statute. The denial letter must be sent either by hand delivery, electronic mail, or certified mail return receipt. You have to include the basis for the denial in reasonable detail or the conditional approval. So you have to be specific. You can't just say denied. You have to explain why it was denied or why it was conditionally approved in reasonable detail. And then you have to give the homeowner a right to request a hearing within 30 days, and to let the homeowner know that the homeowner has a right to appeal the denial or the conditional approval, the ACC decision, to the board. So all of these need to be in that denial letter. So make sure, again, you're working with your legal team on that. In terms of the actual hearing, as I said, it follows or tracks how the old 209 compliance hearings are or were. Now those are different, but the hearing has to be held within 30 days. The homeowner has to be given 10 days notice of the hearing, the location, time, and date. The hearing's purpose is an opportunity to verify facts and discuss the resolution of the denial. What can we do? This is the denial or the conditional approval. This is our position or opinion, and can you help us? Only one postponement unless agreed by both parties. Either party can record the hearing. And then this other kicker that we're going to talk about is that it has to be in the open session under Texas Property Code section 209.0051H7, which is one of those lovely 15 items that have to be held, or the decision that the board makes, votes, and considers on in an open session. This is my fancy slide that stars the ACC appeals as one of the 15 items that has to be in the open session of a regular board meeting. And I hear you guys, oh, but Cipra, this makes our board meetings even longer. And who wants to talk about, ACC appeals in the open board meeting? What we are recommending, and I'll back up just for a second, is to provide a process either in your template for your denial letter to tell the homeowner that you're gonna, while you're entitled to have this hearing in an open board, in the open board session part, if by agreement we can have the hearing in the executive session, that's what the board would prefer, but recommend that it occur in an executive session or in a separate meeting with the board. And as long as the homeowner agrees to it, which I think most homeowners, again, don't want to air their dirty laundry with ACC application denials and questions. Maybe some do, but most of them don't. They're going to hopefully agree to have it in the executive session or in a separate meeting. Okay, so the approval process and violations. This is really important to me, and I think sometimes associations get trapped in these issues. And so I'm going to say this a couple of times. If once the application reaches the Architectural Control Committee or is submitted, really, I mean, that's kind of when the date timestamp is, the association should really work to respond to the application quickly and review it as quickly as possible. And I hear you guys, these are volunteers and we're kind of fitting it in between work and babysitting and life. And we're volunteers. We don't get paid for this, but you really need to try and get people that are going to move on these as quickly as possible. And really, I can't say this enough. Send a denial letter ASAP if the ACC application is insufficient or contains missing information, I guess is missing information, and specify what's needed. A lot of times I have associations that come to me and say, well, we didn't respond because it says you have to submit a complete application, which includes 2 plans, and they only submitted 1 plan. So we're not going to respond. That's out there. I'm going to really encourage you guys to avoid creating a situation where there is a failure to respond. That's never okay. And even if it's been denied because it's not complete, at least that's a denial letter with reasonable detail. I would encourage you guys to do that if there's anything missing. The reason why this is a problem is that darn deem approval restriction in the ACC guidelines, or the restrictions that says If an application is not approved or denied within 30 days of receiving the application, then the application is deemed approved. And that, guys, will sink you. It is not easy to defend a lawsuit where that express provision is in the deed restrictions, because here we are beating our drum about complying with the deed restrictions and the exact same language of the restrictions, and the homeowner's not doing this and the homeowner's not doing that. When we end up in court and the homeowner's arguing about what we're not doing, especially if it's expressly provided in the restrictions, this really looks bad. And oftentimes homeowners rely on this deemed approval, and they will proceed forward with construction. And then we've got an even harder situation to deal with, because courts don't like to make people tear stuff down. It's expensive. And there's an equitable argument. It may or may not win, but there's an equitable argument about the time, money, and resources that this homeowner has spent in moving forward with construction on a deemed application that is just a really difficult, hill to climb. So we don't ever want to be facing that situation.
Sipra, we have a lot of questions coming in, so let me just try to touch on a couple, and then we can hold the rest for the end. One is just seeking clarification. If I'm understanding the requirements for the hearing language correctly, the hearing requirement language must also be included in both the denial and conditional approval letters, not just the denial letters.
That's correct.
Okay. The other one is, if governing docs state DRC has 3 members, can the number of members be reduced as of 9/1/21 without amending the documents?
If I understand the question correctly, I don't think it can be reduced, because your restrictions are your restrictions. So you have to have 3. And I would actually encourage, if you can have 3, to have 3. I think the problem is people aren't willing to serve. So you're not technically amending because you only have 1 or 2. You're just operating the best you can with less than 3. If you need to, if you want to have 2, or if you want to have 1, I guess you could. And if you do, and you want to stand behind that, then I would encourage you to amend, which I know is really difficult, especially with like a 67% requirement. But I would say try your best to comply with what the provisions are in the declaration and deal with the fallout on the back end, because we really don't know what else to do at this point, especially with a lack of volunteers.
One more I'll just throw in there real quick. This is a question we get a lot through our HOA hotline. If the homeowner does an improvement without prior approval and submits after the fact, do these same time limits still apply since the offending change is already in place?
Yes, the deemed approval always applies. So once you get an application, that deemed approval ticker starts going, whether there's construction already completed or started or approved or not approved. So I certainly don't want to be defending a case where construction has started, it's completed. We told them to submit an application, they submitted an application, and then we just did nothing and didn't respond timely. You always have to respond timely, no matter what the current situation is with the construction.
Thank you.
Okay, I've got a couple more slides, and then I think we'll have a few minutes for questions. So I'm going to race through the rest of this, but I think I've already kind of hit you guys over the head with this, but once the application is received, important for the ACC to not wait the full 30 days or 45 days to respond. I know you guys are like me and we're all buried, and sometimes I think, oh, I have a couple days to respond. 30 days seems like eternity. And then, 30 days later, you're like, heck, where'd that 30 days go? So just try and do your best and get to that application as quickly as possible, especially if it's an automatic denial process where it doesn't have enough information or it's missing something, and you can't make the decision. If you do wait for a full 30 days or longer, you're opening yourself up, the ACC, the board, the association, the managing agent, to liability for not only deemed approvals, but also for delays in construction. That's why that deemed approval is in there. You know, think about how much money spend on getting an architect and creating applications and paying contractors to start construction. And if we're delaying response times, then it's delaying their times. And as lumber prices rise, right, a week delay in responding to an application could mean the difference between $1,000 or $5,000. So I would encourage you guys to respond anytime as quickly as possible. On rare occasions, when you get an application, you're going to have probably the ability to automatically deny it because there's a setback violation or something like that that can't be approved because it's against the restrictions. However, everybody probably has heard of the term variance, and oftentimes some associations and ACCs have the authority to grant a variance from the restrictions. We are conservative on granting variances, and we encourage one to make sure that you have authority to even grant a variance, because if you don't have authority, then it's really easy. Look, I understand that your garage is 6 inches off the side setback, but we don't have authority to grant variance, and so we're stuck. And you kind of have to be okay with the fact that you don't have variance authority. If you do have variance authority, I really encourage you to be careful in when you use it. Really, variances should be used when there's an extreme, like extenuating or extraordinary circumstance that makes it really difficult for the construction of the home or the modification to happen because of the topography or the setbacks or the nature of the lot. I just had this situation recently where, just for aesthetic reasons, the homeowner wanted to violate a setback issue. Well, this was like a 20,000 square foot lot, and they could construct what they needed to construct within the setbacks and the guidelines that were there, but they just thought it looked better if they tweaked something. I really encourage you guys to make sure, if the ACC is considering a variance, that it's really for a limited reason where the nature of the land requires that the variance be granted. The post-approval process and violations, a lot of times people think, well, once we've done the application approval, our job's done and we get to kind of hunky-dory, go off our way and look to the new application. Equally as important as reviewing applications is making sure that what's constructed after you've reviewed the application is actually what was approved. So an association, whether it's by your ACC or your managing agent, whoever, needs to really try and do some type of at least visual inspection of the property to make sure it was constructed in the same manner that it was approved, and that there wasn't anything else constructed that was unapproved or modified during the construction process. I have associations that sometimes require as-built plans after their construction so that you can confirm that what's built is actually what was approved. I don't love for my board members and even my managers to go on to a lot to do an inspection. But if you do, just be mindful that, you really need to get approval from the homeowner. And if the homeowner doesn't want to give it to you, then you don't have any business being on that lot. You don't want to create liability by doing something that you've been asked to not do. But really important to make sure that you're following up with the homeowner on the post-construction to make sure it comports with the application, because again, once it's completed, it makes it harder for us to argue that it needs to be modified just from an equity standpoint. In extreme circumstances, you'll have to get your legal team involved, right? If in the instance where the question was asked, what if the construction has already started and completed and there was no application? Or if you see that the construction is going off the rails and the elevation looks completely different, or it's much larger than what you approved or much smaller than what you approved. Again, really important, especially with new home construction and modifications where lots of money is involved, to get in on that issue early and get your legal team or your management team involved to send some type of a stop construction, cease and desist letter. And don't give them 7 days. Say you have to cease and desist immediately, or we're going to have to consider our legal options. And the legal option will be to either file some type of a temporary restraining order or request a temporary injunction to stop the construction immediately. Because the reason for that request is if that construction progresses beyond a certain point, it's going to be really difficult to make or force that homeowner to modify that construction. We might have every right to make that homeowner modify the construction, but now we're kind of up against a wall because you've got a poor homeowner and this angry HOA in a courtroom arguing about, a 1 foot setback violation or something major. It depends, but really keep your legal team and your management team involved in this whole ACC process for the variety of reasons I've mentioned already, but certainly if construction has started without an application. All right, my last slide, and then I'll stop to answer some questions, but I also have association, either managers or board members ask if we can deny an application because the homeowner either has existing violations, it's a builder that's, is not cleaning up and has lots of compliance issues, or they haven't paid their assessments. Unless you have specific authority in your restrictions, which is rare, I don't know that I see it very often, that says you can deny an application for delinquent assessments or existing deed restriction violations or compliance issues, then you need to move forward with reviewing the application. Again, unreasonable delays in holding up that ACC application process is going to create liability for the association, for you, the ACC members. When a homeowner sues, they'll sue everybody. And so you don't want to create a basis for them to find a reason to sue you, especially if that authority doesn't exist. If that authority exists, you can do it all day long. But if not, then move forward with reviewing the application and approving and denying it as you normally would. All right, I think I did leave some time for questions. And so I thank y'all very much for joining us today. I hope that was helpful. I know it may not have answered all of your specific questions, but again, encourage you guys to work with your legal team on the specific issues that you might be dealing with. But Jesus, do you have more questions for me?
Yes, we have quite a few. So let me start with the most recent one. It says a 209 hearing is not a variance. Does a homeowner have to use the word hearing when requesting a 209 or use the word variance when asking for variance?
Well, I think I understand what you're asking. It's hard to know. Homeowners really don't know the lingo as well as we all do. So I would give the homeowner the benefit of the doubt and kind of hear what they have to say, even if they're not using the actual term variance, if they're, just looking to see if there's an option to approve this application, despite what the restrictions say. Basically, they're saying, I want a variance. So give the homeowner a benefit of the doubt. Just because they request a variance, that doesn't mean we have to give it to them. So there's still an analysis that needs to follow when a homeowner is requesting one.
Okay, thank you. And the other question is, what if the ARC committee depends on what the board says and it goes past 30 days, but then we cannot get answers from anyone. So that goes from a timing issue.
So the ACC has to be able to act independently. Based on this new legislation, the ACC needs to act and make a decision, whether it's an approval or a denial. And we can't sit around and wait for the board, because if the board's involved, then there's already a problem. The whole purpose for separating the ACC from the board is to give the ACC independent authority to make decisions, and then give the homeowner the authority to appeal that decision to the board. So ultimately, if the ACC doesn't know or is nervous about making a decision, I guess they can deny it. I really wouldn't encourage the ACC to just deny it, especially if it's something that's approvable, because they're sitting around waiting for the board to respond. But the ACC needs to act, and then the homeowner has the authority to then say, the ACC is wrong or right, or this is why I need a variance, and I'm going to go talk to the board about it.
Next question is, we have a need more information category, which we use without denying. Should we actually deny while asking for more information?
I think you should. I mean, I understand that the purpose of the need more is essentially a denial in my mind, but to a court or to a homeowner who's just sitting around waiting, if ultimately a dispute arises, the fact that there's an express deemed deemed approval restriction in your declaration, it's going to hang you guys. So I would go ahead and say the application is denied until you submit these missing items.
Okay. This was an earlier question. Can you define what constitutes clarifying guidelines and what would be considered a change that requires homeowner review and approval?
I think I used this, but let's say your restrictions through your ACC provision says that the ACC has the authority to review applications with keeping in mind the harmony of the subdivision, including the exterior colors. Those statements to me intend for the association to be able to kind of dictate what the aesthetics of the community will look like. And there's case law about this, but if the aesthetics of your community have been typically, let's say, earth tone colors, so like muted, landscaping, greens and beiges, and you have a homeowner that's requesting a bright blue paint, that's not what I think subjectively most people would consider an earth tone, then what I would think would be really helpful is for the ACC to adopt a guideline or a policy that says, in harmony with the existing colors and earth tone colors, the following are acceptable colors, right? So you're gonna name greens or yellows or beiges or whatever, and you might even have a specific paint palette that you use. To me, that's a clarification, right? You're saying, what are the existing colors that the association will approve? There's no guidance in the declaration, but we're going to adopt this policy that gives us guidance on what earth tones mean. I think I used this example earlier, so I'm going to try and think of another one, but if you have restrictions that say all fences must be 6 feet, then you cannot adopt a policy that says all fences can be 8 feet. That's a complete contradiction. So in order to allow 8-foot fences, even if you're talking about a baseboard, work with your legal team to make sure this is right, but you will probably need to amend your declaration, not just you can't adopt a policy. That's a clear contradiction. If your restrictions require 2-car garages, but you want to allow 3-car garages, then I think you need to amend your declaration, because under the restrictions, only 2-car garages are allowed. So those are examples where if there's a provision that talks directly to the issue and defines that issue pretty specifically, don't adopt a policy, a board adopted or ACC guideline that's in contradiction with those provisions.
This one says, let's see, it says, if you do clarifying guidelines, do you have to file with the county clerk?
Yes, everyone on this call, if you don't take anything away from me today, take this one thing, and this has been the law for several years now. If you intend to enforce a provision, whether it's the color of a home or how long a temporary vehicle can be parked on a driveway, and that limitation or that color is not in some type of a written guideline that's recorded, you're going to have a really difficult time in court. The law says all governing documents have to be recorded to be enforceable. If they're not, then they're void, that they're not enforceable. So if you intend to fight someone on an issue and take them to court over it, it needs to be in a document that's recorded in the real property records.
We have 2 more, and then we'll cut it there. This one may be off topic, but what recourse does a homeowner have when ACC has approved a request but feels the request will negatively affect property values?
What recourse does who have?
The homeowner have.
Well, I mean, homeowners, can always, well, the first step would be to appeal the decision to the board and explain that they think that it'll somehow negatively impact their property value. But ultimately, the only thing the homeowner could do to force a change, especially if the application is in compliance and we haven't stepped out of bounds in approving it, is to file suit against the association or the board and to claim that, they breached some type of a covenant or they didn't live up to their standard of care by doing something or by denying this application or approving this application. By filing a lawsuit, you're creating a situation where the homeowner now is suing the association, and the association's insurance is going to be triggered, and then there's going to be a claims history, and it's messy. And even if the homeowner is going to have an uphill battle, because I will tell you that negative property value litigation is very difficult to prove. I mean, the evidence involved and the amount of probably expert testimony, especially if the construction hasn't even started, is going to be next to impossible. Despite the fact that the homeowner has this uphill battle with this threatened litigation or actual litigation, claiming that their property values are going to be negatively impacted, the association's now going to have to deal with a lawsuit and an insurance claims history. So I encourage, again, everyone on the webinar to work with the homeowners, at least initially, to try and get a resolution before it gets to litigation. But ultimately, a homeowner can sue for really any reason. Now, if they sue, it's their burden, but we're involved in litigation and it's still expensive and time consuming.
Last one, and maybe Sipra, I can email you some questions and we can provide some clarification just for the sake of time. But can an ACC revoke an approval letter after it has been given?
The lovely lawyer answer of it depends and it's gray is probably going to be my answer. Work with your legal team on that specific issue. If it's fast enough, like let's say you send it and 3 minutes later, yes, maybe, right? You can say, oops, sorry, this is a mistake. If a lot of time has gone by and the homeowner has relied on that approval letter, it's going to be an uphill battle for you to revoke it, because if actions were taken in reliance, money was spent in reliance on that approval letter, then again, they have some equitable argument as to why they should be entitled to move forward under the original approval letter. Now, if it's a sheer mistake, it shouldn't have been approved and it should have said denied. I get that. And we've had to deal with those, but I can't tell you that if it was a sheer mistake and this application really doesn't comply with the restrictions and it shouldn't have been approved and we need to revoke it, that's even a slam dunk winning case. It really just depends what the homeowner does with it. It depends on how zealously the homeowner defends or prosecutes the case in reliance on that approval letter. So it's possible, but it really depends on the exact situation.
I think I'll be able to answer this one. Sorry, throw one more at you and really shortly. Just regarding fences, is it possible for an ACC or HOA to dictate the materials of a security wall or even just a landscaping screening wall?
Probably. Again, my attorney answer is it depends, unless there's something really specific in your restrictions, assuming you have authority to adopt guidelines. If you're attempting to kind of clarify and define something, yes, arguably, yes. The security measures is also a new legislative issue that we're having to deal with. I think if I remember correctly, the security measure statute does talk about at least fencing material, possibly. So arguably, yes. Our goal as lawyers is always to find some authority either in your restrictions or state law to do what you're doing. And so if the new legislation says a homeowner has to be able to put up security measures. More generally speaking, it's our opinion that the association should be able to regulate some part of that security measure, whether it's materials. Maybe materials doesn't mean height, but it certainly could mean, wood, wrought iron. But again, work with your legal team to get the right answer or the possible answer.
So how much input does an HOA board have in the ACC, decision process? I mean, there's kind of been that delineating factors. Now there's a clear line, but how do those work now?
So I am encouraging all my associations to not have board members have any input in the process, because again, that's the whole purpose of separating those two functions. The board's going to get its opportunity if the homeowner disagrees with the ACC to put their input in. I have suggested that a board member can be involved, like be part of the ACC in terms of like overseeing it or be the board liaison. Absolutely. Just to have awareness of what the application is and be there. But when that board member gets called to testify about the application process and what involvement he had in approving or denying the application, at least initially, if he can't say or she can't say, I was not involved or I did not influence how the ACC voted or the decision, then we've got problems, because that's the whole purpose. I don't have a problem with a board member sitting there and kind of overseeing it or kind of watching it all happen, but they should not be telling the ACC or advising the ACC what to do on a particular application. Now, if the ACC and the board want to meet and talk about general guidance on questions they might have and restrictions and guidelines, that's separate. But as it relates to an application and the approval and denial process, my conservative advice is for them to be really separate.
Alrighty, we have a few more which we'll answer in the follow-up email, again with the copy of the recording link, PowerPoint, and the CEU certificate. Sipra, any last words?
And good luck. I know that this is a really difficult issue, but I hope I gave you some tools to kind of at least deal with the issues internally and as you go forth with your boards and your ACCs and other managing agents. But your legal team's here to help you. And I, again, encourage you guys to ask those difficult questions. We may not have all the answers, and there may not be any answers until we see some litigation on this, but all we can do is really try our best to comply with the statute at this point. So thank you all so much. I really appreciate this opportunity to be here with you and look forward to seeing everybody in person soon.
Thanks, everyone. And just 2 quick plugs. We have a board workshop on March 26th, that's a Saturday up in Cyprus. We have a trade show on April 20th. And I want to plug once again, if you're not happy with any of these changes, we need you to get involved in TLAC. That's our advocacy wing, that's our lobby group. And our lives have been made pretty miserable since the last session. So we want to try to correct a few things, and we're going to need your support. Thanks again, everyone. Have a good day and take care.
Thank you, Jesus. Thank you, Sipra. Everyone take care.
Thank you.